No, it's a different
Different.
item number. It's a civil revisional application.
अच्छा.
The trial court date is on 28th. And
28.
20.
20. अच्छा.
Next week.
Hmm.
Your Lordship, I'm facing difficulty there because no adjournment is being granted. If Your Lordship will fix any date, I can next at next Friday is closed.
Next Friday is
38th is the next date.
30th.
Kindly fix at a time so that I can get it heard up.
What is the impugned order?
Impugned order is a person has in the plain, the person has stated that he is not in possession, he wants status quo with respect to the property.
Not in possession. Admitted.
Admitted in
plain.
the plain. Admitted in the
being landlord.
No.
Being a
Tenant.
co-sharer.
Claiming a tenancy. Claiming a tenancy in a shop room, workshop. He says that he is out of possession for more than 10 years and he is not allowed because it is his.
Declaration and injunction.
Yes. And what the court did, the court passed an order not to dispossess him. The plaint and the injunction application states something else. The court passed an order which is not there in them.
Is there anybody appearing?
Yes.
On behalf of the
We have served
tenant?
notice. Caviator is there.
Is there?
Yes. So kindly fix a date. I'll serve a further notice on 30th if Your Lordship will fix a time.
Council.
2 p.m. or something like that. I'll give them a notice.
Council. A date and time can be fixed. A date and time can be fixed in presence of both sides.
So I'll give them. There are 2 weeks now.
Let them be present. Request them to be present at 12:30 or 1 p.m.
Your Lordship, it's today. Your Lordship will or let it come up as to be mentioned. I give them notice on 30th.
34. Okay. It will be not this specific item. The entire CO will be at the top.
Because second appeals are there. It is not.
It will be at the top.
That will then it will serve my
because from now onwards, one Friday the second appeal will be at the top.
Then it will be taken up.
Friday.
No difficult.
Already Friday. From coming week.
Or Your Lordship may do first half, second appeal, second half revision. That will do.
That can also be done. But the question is whether the second half is available or not. That is the question. Yes. That's why. Otherwise, it would have been better to have the CO civil revisions first in the first half and second appeal in the second half. That CO na এরপরে দিকে 30th CO গুলো আগে দিয়ে দেবেন ঠিক আছে তারপরে সেকেন্ড appeal ঠিক আছে
that will serve the purpose.
My lord, may I be allowed to mention one hearing upon mentioning?
No, there won't be any pick and choose.
No, all matters. Let all matters. All.
May I be allowed to mention one hearing matter, my lord? Second appeal upon notice, my lord.
For notice. Is any application pending?
No, my lord, no application.
Ready for hearing?
Yes, my lord.
Paper book?
Yes, my lord. I'm for the respondent, my lord.
No.
Yes, my lord. Everything is ready, my lord. Grateful, my lord.
Yes, you were mentioning on the earlier occasion on last Friday. But where is the?
I attempted.
Is the matter appearing in the list? No. Where is the mentioning slip? You provide a mentioning slip. No. Learned senior counsel. Provide a mentioning slip. Provide a mentioning slip. Provide a mentioning slip.
I will.
Yes.
At least 50 times I mentioned. Case number 629. আমি দিয়ে দেবো আপনাকে
mentioning slip নিয়ে নেবেন.
The most unfortunate fact is that the title suit was filed by us.
You are for the partition suit.
Partition suit.
You are for the appellants.
I am for the appellants.
The respondents are being represented.
Previously, they were represented. Unfortunately, since expiry, they have not taken any care.
Expiry means a sole respondent
There
or
are
more than one respondent.
more than one respondent.
So somebody has expired out of the respondents.
And cost was imposed upon them. Cost was paid by them. Thereafter, they actually made a construction over the property. Partition.
Alright, council.
Yes, madam.
Let me be clear.
Excuse me.
The fact is that a mentioning slip
Yes.
is to be
Provided.
furnished. And prior to mentioning it, the other side has to be apprised that the matter is being mentioned on this day or that day.
The fact is that most unfortunate.
Be kind enough to apprise the other side in writing and provide
At
the
least
mentioning slip.
I will show 50 times and matter appeared before your lordship. Matter appeared before your lordship, and I can show the actually this. There are records from which it will appear in courtroom 11 when
Yes, whatever has occurred before any other bench, that is a
before
closed
your
chapter.
lordship's bench.
That is a closed chapter.
Yes.
Herein, it will be listed. It will definitely be listed. But prior to that, am I audible?
Yes.
Prior to that, let the other side, when somebody is representing the respondents, let the other side be apprised.
Yes. Since your lordship is telling that I will again apprise them. Again.
No, not verbally. Serve a notice upon them that the matter will be mentioned on 30th.
Yes.
Because we don't have on 23rd. So 23rd holiday. So on 30th, the matter will be mentioned. Have an endorsement. If they refuse to endorse it, that
they are not found. Where I will mention
there is somebody representing the respondents. Serve upon him. If he does not receive, if the case is otherwise, then you mention it that they have denied to accept it. Then it will be automatically coming up in the list.
Unfortunately, since they have made construction, they have done everything.
Yes, Mr.
We are sitting.
Mr. Shannal,
Yes.
let us be within the procedures. You are senior counsel. You are senior counsel. I need not be apprised of these things.
I am not designated as seniors. But I will remain as.
But in this profession, you are a senior.
Yes, I will try.
On 30th, you mention it with a mentioning slip. It will be in the cause list.
30th, before 30th.
Before 30th, might not be because next Friday is holiday.
Only one day, that is Friday.
They were talking.
Item number 1.
Not within the courtroom.
Not even the flight time.
No comment. Mr. Bhattacharyji, you have completed?
Yes. And we will reply.
Yes.
My lord, on the
Earlier occasion.
concluding his submission, he made submissions regarding payment or non-payment of the consideration money, not passing of consideration money to the vendor, citing section 58C of the Registration Act and also section 54 of the Transfer of Property Act.
Can it be apprised by one or two sentences?
That there was no consideration money passed to the vendor by the vendee, that is my clients.
You could not show any,
No. There are evidence. There are evidence.
Yeah.
And in the deed itself,
deed of sale.
deed of sale. And
Acha,
Acha.
the person has expired on the very next
One
day,
day-
on the
one-
very
one day
next day of execution, of the date of execution
yes,
of the
yes.
deed.
And
Yes,
taking
yes.
the
I
advantage of
was
that.
showing the DW every evidence
Uh-huh.
regarding.
That
Yes.
compounder.
Compounder.
Actually, as regards to any matter, only one word or two words are sufficient.
Compounder.
Compounder.
Yes.
Omeo.
Omeo Kumar Ghoshal.
Yes.
My lord, this point of non-payment of consideration money is, my lord, not covered by or under any of the substantial question of law as framed. Wait. If you also kindly again take a very little view of the point substantial question of law as framed by the order dated 5th of October 2018. Substantial question of law.
Yes.
Number one, whether I have placed earlier, please again I am placing it. Whether both the courts value substantially erred in law in facts by dismissing the suit filed by the plaintiff appellant without considering the material evidence on record. Then whether the court below erred in discarding the evidentiary value of the medical certificate issued by the registered doctor on the illness of Haran Chandra Ala when the said medical certificate was exhibited without objection. It should be with objection, as it is evident from the depositions. And therefore,
On consent of both sides, this one can be rectified.
Yes, I showed your lordship the records itself. That is a
if it is
incorrect record.
rectified, then there is.
Let an order be passed.
My lord, I have
At the end of
I
that
have something to say. If it is rectified that with objection, then this particular substantial question of law frame number 2 loses its character as substantial question of law.
Let it be there. It will be dealt.
Yes. Then third, whether the Court of Appeal will err in dismissing the suit even after recording the finding that it is a fit case for remand. On the last occasion, your lordship may kindly remember that I placed that although the court thought fit or my lord took a view that it should be remanded back, but thereafter the learned appellate court below.
No, from this end, there has not been, till this moment, there has not been any opinion passed.
No, I'm not
as
saying.
regards to remand.
No, I am saying about the remand question came before the first lower appellate court. First appellate court.
First appellate court.
Now the first appellate court, although took a view that it should be remanded, but thereafter making a lengthy discussions, held that in view of those discussions, it should not be again sent by remand to the trial court for decision, because it may be decided here, and that was decided by the first appellate court. So there was no question that simpliciter that the findings of the lower appellate court for remanding back, that is not correct. May I, my lord, for the sake of my lord recapitulation, place
No, that portion need not be.
because there is the lengthy discussions in the lower appellate court judgment.
First appellate.
Now, Lord, first appellate court, not lower appellate. Sorry. Then 4. whether the court below erred in not drawing a presumption of the purported deed was not executed by Haran Chandralala with free mind and on his own volition a day prior to his death, overlooking the certificate issued by the registered doctor that he suffered from cerebral attack and was incapable of taking decision. So, if we minutely analyze these four question of law, substantial question of law, nothing related regarding, my lord, the payment of consideration money is not related with none of these substantial question of law.
No, that you have
The-
stated first,
Yes.
non-payment of consideration money.
Therefore, my lord, according to as per provision of section 100, that after the substantial question of law is framed and admitted for hearing, that means the hearing of the appeal will be, my lord, on the substantial question of law framed for hearing on admission. Therefore, if the issue of payment or non-payment of
But at the time of hearing,
yes,
if it arises that further substantial question of law is
to be framed,
required to be framed, then
is
it
to
can
be
also
framed with recording reason, recording reasons. Is to be framed, reframed.
That is the full.
Yes, reframed. Section 100 clearly says it has to be framed, and then the parties will argue. Unless and until it is reframed, probably
The principle is that both the sides should get the opportunity to
yes,
submit on that
argue
point
on
of
that
law.
reframed substantial question of law. Unless and until this is framed,
But
probably, my lord.
But till now, we are within the four substantial questions of law which have
Yes,
been framed.
yes. Until and unless reframed, other additional substantial questions framed, then we cannot make submissions on the point which are not related to any of the substantial question of law. Number one. Number two, my lord, even we assume but not admit that this point of non-payment of consideration money is somehow related, somehow, remotely. Then what is the scope of endorsement under section 58(1)(c)? Let us consider.
Transfer property, actually.
Registration Act. Registration Act. Sorry, registration Act. 58(c) registration. May I hand up this question? Registration. Yes.
Yes.
This section, my lord, is covered under the heading as to the procedure on admitting to registration. This is procedural provision for admitting a document for registration. This is procedural law. Now, kindly see 58(1)(c). May I place it before you? Any what is to be endorsed, amongst other what is to be endorsed? Any payment of money or delivery of goods made in the presence of registering officer. Well, kindly note it. Made in the presence of registering officer. I repeat, made in the presence of registering officer. Any payment of money. In reference to the execution of the document and any admission of receipt of consideration in whole or in part made in his presence in reference to such execution. So, my lord, the obligation of the registrar to make endorsement regarding payment of money, consideration money, relating to execution of the deed will arise if such payment is made in his presence. Otherwise not. Kindly note it, madam.
Yes. Yes. Somebody is here.
So it is subject to endorsement, obligation of
So
endorsing, making endorsement.
According to you, the respondent or respondents, whatever may be, as per the case, has paid money prior to being placed before the registrar.
Yes. I'm coming. So no payment has been made in presence of the registrar. Prior to. If it is prior to, then obligation under 58(1)(c) does not arise. If payment is not made in presence of the registrar, no obligation.
আস্তে কথা বলতে বলুন।
We are really in seminal mode. My lord. My lord, I have seen, I have the opportunity to see many a document registered did. I have never seen such an endorsement because payments are already made, executed before registration. I mean prior to registration, execution, then it is placed. Therefore, no question. However, then my lord, this point of payment or non-payment of consideration money and its effect together or in a situation where the contents of the deed registered contain the admission of the vendor or the executor regarding receipt of consideration money. When such an admission is made in the deed or contained in the deed, then what will be the effect?
It is there in the deed.
Yes.
ট্রায়াল কোর্টে রেকর্ডেড
দিতে দিন না।
না ওই টিন বক্সে
তিন বক্সটা আছে।
টিন বক্সে যেটা ডিডটা আছে
এটা না, এটা না। এখানে ওখানে ওখানে ডিডটা না, ওই এটা দাও আমাকে ওই। আচ্ছা, এটার মধ্যে আছে। ডিডটা কোথায়? আচ্ছা আচ্ছা, ঠিক আছে। হ্যাঁ, ব্যাপার আছে একটা। Got it. First, second. Let us come to third page.
Middle portion,
Middle portion.
place it.
My lord. কোত্থেকে সেন্টেন্সটা শুরু হচ্ছে সেটা দেখতে হবে। সেন্টেন্সটা কোত্থেকে শুরু হচ্ছে দেখুন। জমি বিকৃত সম্পত্তি হইতেছে। এক্ষণে আমার
Let the paragraph be placed.
yes
কষ্ট
আমার হাল রিভিশনাল সেটেলমেন্ট রেকর্ডে নিজের নামীয় এবং হাল হলকা রেকর্ড নিজ নামীয় রায় দখলি সত্ত্বে জমি জমা নিঃসত্ত্ব সাফ কবলা পত্র মিলন কার্জন জাগে জেলা 24 পরগনা অন্তর্গত থানা ও মৌজা নিম্ন তহসিলে বর্ণিত মোট 1 একর 70 শতক জমি বিকৃত সম্পত্তি হইতেছে। এখন আমার অসুখের চিকিৎসার জন্য এবং নানা কারণে টাকার বিশেষ আবশ্যক হওয়ায় উক্ত জমি জমা বিক্রয় করিবার ঘোষণা করিলে মহাশয়গণ মহাশয়গণ মিনস মাই লর্ড পারচেজার উক্ত জমি জমা খরিদ করিতে ইচ্ছুক হইয়ে এখনকার বাজার দর তো এটা নাকি উচিত মূল্য 40,000 টাকা পণ গ্রহণে
বাজার কি পরাপর
বাজার পরাপর
what is the meaning of that word? উচিত মূল্য
40,000 টাকা পণ গ্রহণে উক্ত জমি জমা মহাশয়গণ নিত্য শক্তি বিক্রয় করিয়া সো পণ গ্রহণে বিক্রয় করিয়া
You are referring to this portion.
Number 1. Next, my lord. Next page, page 4. First, second, third, fourth, fifth. Last but fifth from bottom.
এই সকল
Yes. এই সকল খাতে আমি ওয়ারিশগণ সহ বাধ্য থাকিয়া ও পণের লিখিত সমস্ত টাকা নগদ বুঝিয়া পাইয়া স্বইচ্ছায় সজ্ঞানে অত্র নিঃসত্ত্ব সাপ কবলা দলিল সহি সম্পাদন ও রেজিস্ট্রি করিয়া দিলাম। So that is admission that he got in the deed itself. Then what will be the effect? My lord, we have, my lord, got এখানে আমাদের বারও পাইনি সে কালকে আমি যার জন্য আইসিসি অনলাইন থেকে I will be relying upon a judgment of Odisha High Court. I'm giving the citation. Lordship High Court. ঠিক আছে স্যার ওই AR 1977 Supreme Odisha, AR 1977 Odisha. Yes, it was AR 1977 Odisha. Page 178. আমার মনে আছে মানে সেখান থেকে বলছি আমি কিন্তু এখানে পাইনি বলে এসসিসি অনলাইন নিতে হলো এসসিসি ইকুইভ্যালেন্ট 1977 এসসিসি অনলাইন 1977 এসসিসি অনলাইন Odisha 30 1977 Odisha 178.
You are referring to
AIR 1977 Odisha 178.
178.
Paragraph 11 and 12. Paragraph 11 and 12 SCC online. And in AIR it is paragraph 6. Paragraph 6. I am placing before Lordship SCC online. In SCC online, paragraph 11 and 12. There are corresponding
citation is
1977 SCC online.
1977 SCC online.
Odisha 30.
30.
Paragraph 11 and 12.
Yes.
But I will be relying upon paragraph 11, 12. Before that, I asked one line facts of the case. There were 2 executors. One executor died. Now, the other executor admitted in the deed that both of them received the consideration money in the deed. Question came whether non-payment of consideration money there was sale or not under section 54. It was dealt with.
As regards to the other executant, registration took place within
Which this in the cited case. Oh, registration took place.
you're saying that there were two
Two
executants.
executants. Well, just
One-
I'll place one
Yes.
or two paragraphs.
Yes.
Paragraph 11 of the two. My lord, I will just one copy, my lord, because I from our library also I could not get. Of the two executants, Ujjal is already dead. Maybe during pendency of the suit. Maybe. Oh. I'm sorry, my lord. I can't refer.
Need not.
Yes, it's online. Paragraph 11. May I please? Of the two executants, Ujjal is already dead. This fact is not disputed. From the contents of Exhibit B, that is the deed, it appears that Ujjal admitted receipt of consideration. Therefore, at the time of registration, he was alive. The admission by Ujjal is admissible under Section 32(3) of the Evidence Act. This principle has been clearly laid down by this court in so-and-so, and 67 Mauritius, and so-and-so, 1972 Cutoff, WR. The admission made by Ujjal in the document about receipt of the consideration money is also good piece of evidence in support of passing of consideration. Next paragraph 12. The scribe of Exhibit B has also said that according to the instructions given by the vendors, the contents of the documents were written out. The evidence read with the contents of the document clearly supports the question of passing the consideration. Here, my lord, I am also going back to the contents of our deed. Here also said the executor admitted
The fact that he has
he has
received.
received. Pon Grohone. The evidence read with the contents of the documents clearly supports the question of passing of the consideration. Then simply because, then paragraph 13, simply because there is discrepancy in evidence of witnesses as to whether amount was paid before the sub-registrar or prior to the registration, it cannot be said, in view of the aforesaid materials available on record, that court will come to the conclusion that there was no passing of consideration basing on the oral testimony of witnesses. I am on this. Court will not come to the conclusion in view of the contents as per material evidence on record. So therefore, my lord, on the face of the deed, admission is there. My lord, therefore, following this judgment, this court may kindly take us note of this, that because of the admission, there may be discrepancies. Somebody said, Khepe payment koriche, but there is no document to show. There may be discrepancies. But here said that when the executor is admitted,
Court has to rely upon the what is written in the mentioned in the document.
yes, grateful to your lordship. In the document itself, he said, he has admitted, he has got the money.
That has taken place during the course of transaction.
Yes. And he has said in the deed itself.
That is to be taken into consideration.
And that is mainly, it is admission on the part of the executor.
Yes. This point is over.
Oh, yes. May I hand up this one? Page 170. Oh, sure. Now, my lord, regarding obligation, I've got another point. Obligation to endorse the receipt. That was not in presence of the, there was not in presence of the register, therefore there was no endorsement. Another point is this. This is a procedural law. Without any provision of any consequence, if the procedural obligation is not discharged. Am I clear to you? There is no provision under 58(1)(c) or under section 58 that if any of the function or obligation is not discharged, then so and so will happen, cost will be imposed or anything. Any consequence, no mention. Then what will be the fate or what will be the nature of this provision? It will be a directory, not mandatory. It will be directory, not mandatory. I will be relying upon a judgment of 19. Well, Lord, kindly pardon me, I could not get time to get the Xerox. I'm showing you, Lordship. Citation is 1993 Supplementary 2. 1993 Supplementary 2, SCC 611. Head note says interpretation of statute, mandatory or directory provisions. Inference of held par shohaije. If something is required to be done and consequence of not doing it are also provided, consequence of not doing it are also provided, such action is mandatory. একদম দেখে উঠতে পারি কি করি বলতে দেখে উঠতে পারি কি করবো বলো এটা একটা দিন না অনেক আগে নোটিং এটা আজকের নয় অনেক পুরনো আমার দাগ দেওয়া রয়েছে এগুলো সব অনেক পুরনো কালকে এসব খুঁজে খুঁজে বের করতে হয়েছে চেষ্টা করছি বললাম তো তোমার ফ্লাইট কোথায় যাওয়ার তোমার জলপাইগুড়ি যাওয়ার ফ্লাইট কোথায় আচ্ছা That is why, my lord, I sought more time to come up before your lordship to give my reply.
Yes. You are relying upon paragraph?
Interpretation of statute. Paragraph I could not find out, my lord. Your lordship, I will file, my lord, a written notice of submission giving paragraph. খাতা থেকে খুঁজে বের করতে অনেক সময় লেগে গেছে Yeah. Okay. Minority views are there, so why is majority views? Come on. Okay. I noticed that दिया था यार.
You are relying upon 619 paragraph 19.
I see, my lord.
The notification therefore provided not only the conditions which a candidate was required to possess when applying for the post mentioned in the notification, but he was also required to support it with authenticated certificate, and if he failed to do so, then the application was not liable to be entertained. In legal terminology, where something is required to be done
Oh, I'm
and
grateful. my
the
lord.
consequences of failure to do
Paragraph
so
19.
are also provided, then it is known in legal terminology where something is required to be done and the consequences of failure to do so are also provided, then
It will be mandatory.
it is known as
Mandatory.
mandatory. The mandatory character of possessing the requirements as provided in the first part of the notification stands further strengthened from the third and last part of the notification, which prohibited the candidates from applying if they did not possess the requisite qualifications.
I'm grateful, very, very grateful to your lordship that your lordship could find out paragraph number also. There was about it. Paragraph 19.
19.
19. So, my lord, here in entire 58 of Registration Act, there is no such provision of consequences if not done. Therefore, it is not mandatory directory. Number one. So, my lord, these 3 points, if I may summarize, that it is not covered by any of the substantial question of law framed for while admitting the appeal. Number two, because the contents of the deed speaks of admission of getting the consideration money. Therefore, howsoever there may be conflicting or finding evidences regarding payment, the court will not come to a conclusion that there was no consideration money passed on to the vendor. Number three, it is directory, not mandatory. Therefore, these point of non-endorsement on the deed registered by the registrar does not prove that the consideration money was not passed to the vendor. Another and last point is this, that both the court below made findings regarding payment of consideration money on the basis of the evidence, both the court below. In my respectful submission, that when such concurrent findings of fact are recorded by both the trial court as also the first appellate court, the High Court will not disturb such concurrent findings of fact. The judgment আমার আছে পেপার বুকটা এই যে পেপার বুক এখানে এটা থাকবে এখানে একটা judgment আমি it is well settled my lord. I've noted but কোথায় আছে also very good, huh? I'll be relying upon a Supreme Court judgment on it right now. Findings are for regarding the exhibition as Supreme Court judgment in Ibrahimuddin case সম্ভবত just a minute. Right. Concurrent findings of fact, howsoever erroneous, cannot be interfered with. Yes, Codiva versus 1999 1999 Supreme Court 2213 para 4. Two two 13 paragraph 4. It is settled on 1999 Supreme Court. খুব সম্ভবত আছে দেখো তো আমার মনে আছে 1999 Your Lordship will carry for I will supply the Lordship. Nineteen 1999 Supreme Court 2213 para 4. Codiva versus Savitri Bai. ছিল আমি খুব সম্ভবত জাজমেন্ট পড়া আছে দেখো তো 1999 Supreme Court জেনেছি এখানটার মধ্যে আছে DW2 evidence tabulation. DW2. ঠিক আছে, দিয়ে দাও। ঠিক আছে, নোট করছি। আমি তো এটা লিখে দিই।
You are relying upon paragraph 5.
Paragraph, my noting is paragraph 4, maybe paragraph 5.
It is not within the domain of the High Court to investigate the grounds on which the findings were arrived at by the last court of fact. Being the first appellate court, it is true that the lower appellate court should not ordinarily reject witnesses accepted by the trial court in respect of credibility, but even where it has rejected the witnesses accepted by the trial court, herein there is no rejection. both the trial court and the first appellate court have,
Found-
both have come to the same view.
Conclusion that payment was made. Payment was made.
There's no contradiction between the trial court and the first appellate court.
Yes.
Hearing.
So let us not rely on this, my lord. Or if it is, my lord, I will I will submitting before lordship the written notes of submission. I will approve the judgment. I will annex and close.
No, you are relying upon this one, but that is not apt to this
Apt.
list.
If it is contradictory,
Not contradictory, not similar in fact. Yes.
but it is settled law that I have got other judgment also that if both the court below made
in the
concurrent
second
findings of
appeal, need not interfere with that one.
yes, even if there is what is that part? Even if there is howsoever erroneous can be, the facts howsoever erroneous can be. So, my lord, therefore, my lord, as per the findings, concurrent findings of both the court, should I, my lord, place before lordship? Your lordship is already
No, the fact has been placed by them.
recorded. Both the court found that the consideration money was paid. Quoting the DW's version. So, my lord, at this stage of hearing the second appeal, the High Court, Honorable High Court will not interfere with the concurrent findings of that. So, my lord, these are the 4 points regarding non-endorsement made on the deed registered and relying on the judgment of the Odisha High Court Division Bench, my lord. Even if there are some evidences, not contrary, but how did you say that? The court will not come to the conclusion that there was no consideration money passed to the vendor. So this part is over, my lord. Then, my lord, regarding other points, the judgment cited by learned friend on these points. To 18, I thought you get. নোটিংটা কি করেছিল, প্যারাগ্রাফটা কি বলেছিল? 2218 paragraph.
3 judgments have been cited.
Yes, 22, volume
22.
18 SCC 489, 1972 1 SCC, page 9, para 1819, and 2025 SCC online. In 2025 SCC online, 1972 was referred to. That is why I am not touching or I am not placing the 72 1 SCC. Now, my lord, in 2025 SCC online, paragraph 30 onwards, laid down the effect of non-payment of consideration money. That is covered by section 50 of the Transfer Property Act. Non-payment, no consideration, no sale. If there is no sale, deed void. That is the contention. Now, in this judgment, nothing has been laid down about the non-endorsement of the sub-register regarding payment of consideration money. Nothing. I've read it. Only the effect of non-payment of consideration money. Therefore, if the consideration money passed to the vendor as admitted by him in the deed, then, my lord, these 2025 SCC online 1962 will not come to aid of my learned friend. Paragraph 33 onwards, I have read the entire judgment. If I may place.
Envelope to the envelope.
প্রেমসিংটাই হচ্ছে 72। এসসি অনলাইন করে না? In this case, the plaintiff filed the suit for injunction. Suit was dismissed. Plaintiff then filed the first appeal before the first appellate court. The contention was that the plaintiff did not receive the sale consideration.
Herein,
Did not receive
donor was alive,
yes.
but in your case, he has expired.
Expired. He has expired. No, regarding consideration, receiving or getting the consideration money. No. Contention was that she did not receive the sale consideration.
She never obtained any sale consideration.
Consideration money. Then, my lord, appeal was filed, defendant being dissatisfied. Suit was decreed, then defendant filed appeal. In the appeal, suit was decreed. In the appeal, suit was decreed. Set aside the then before the Honorable High Court, defendant being satisfied, suit was decreed. Appeal. Dispute appear before the court, 2384, handwriting expert, so and so. Law of point of limitation was also involved. As after my findings, I do not find any illegality, perversity in the findings under challenge, which are based upon the appreciation of oral and documentary evidence, much less to substantial question of law arise for adjudication of the present appeal. No other argument has been raised. In such circumstances applicable, the legal heirs of the original defendant are here before us with the present appeal. Now, as I have submitted before your lordship, regarding non-endorsement of the of payment of consideration money was not the case before the suit. In this case, was not the case made out in both the court. My understanding related upon paragraph 33 of this judgment. Paragraph 3, may I please paragraph 33. In fact, it is logically impossible for a person who is not a party to a document or to a decree to ask for its cancellation. This is clearly explained by Wordsworth J. in the decision rendered in so and so. Then paragraph 34. Therefore, filing of a suit for cancellation of a sale deed and seeking a declaration that particular document is inoperative as against the plaintiff are two distinct and separate suits. The plaintiff in the present case, not being the executant of the sale deed dated 5/5/1997, executed in favor of the respondent number 1, original defendant number 14, was therefore not obliged to sue for its cancellation under section 31 of the Act 1963. Here also the plaintiff appellant were not the executant, were not the vendor of the deed of the suit property. Finally consider this aspect, paragraph 34. Oh no, it is it is quoted. It is under paragraph
The
30. Paragraph under 30. It is under paragraph 30.
Mm.
Under paragraph
in
30.
fact,
Quoted from other judgment.
yes, 1939 SCC Online Madras 149.
Yes. SCC Online Madras 149. When the plaintiff seeks to establish a title himself and cannot establish that title without removing an unsuperable obstruction such as decree to which he has been a party or a deed to which he has been a party, then quite clearly he must get the decree or deed cancelled or declaration void in toto, and his suit is in substance a suit for cancellation of the decree or deed, even though it is framed as a suit for declaration. But when he is seeking to establish a title and finds himself there, threatened by a decree or a transaction between third parties, he is not in a position to get the decree or that deed cancelled in toto. That is a thing which can only be done by parties to the decree or deed or their representatives. Here, although the executor died, his proper remedy, therefore, in order to clear the way with the view to establish his title, is to get a declaration that the decree or deed is invalid so far as himself is concerned, and he must therefore sue for such declaration and not for cancellation of the decree. Proper relief is for declaration that the decree or deed is invalid. Let us see the prayer in our case, in the plaintiff. The plaintiff. May I place your worship, your worship?
What is the prayer in the plain?
Yes, I am placing. বাদীর প্রার্থনা এই যে নালিশি জমিতে বাদী সত্য সাব্যস্তের বিবাদীগণের নাম বরাবর হারানচন্দ্র আলা সম্পাদিত তারিখে দলিলটি vitiated by fraud, undue influence দ্বারা সৃজিত ভুয়া কলুসিভ ফ্রডুলেন্ট দলিল থাকা প্রচারে বিবাদীগণ যাহাতে বাদী শান্তিপূর্ণ দলিল স্থাপন করে। For declaration that the deed dated 31/8/1998 vitiated by fraud. But here said his proper remedy, therefore, in order to clear the way with a view to establish his title, is to get a declaration that the decree or the deed is invalid so far as he himself is concerned. Now, again, my lord, prayer is dolil vitiated by fraud, undue influence. Declaration that the deed is vitiated by fraud and undue influence. Declaration.
That is their contention.
That is the prayer.
Mm.
Now, here it is said
That the
agree.
person was not in the fit state of mind,
That is
either
another
physically or mentally,
yes, that is another issue.
to execute a deed.
When the executor died, then his proper remedy to seek this declaration, not this one. Then, my lord, paragraph 33, may I please? Further, as per state of Maharashtra Supra, it would be of no consequence even the plaintiff is in one of his prior seeks a declaration that the sale deed is nullity or invalid insofar as he is concerned, since such an instrument would anyway be void owing to it being fraudulent. Therefore, the period of limitation for the suit for possession based on the title would continue to be governed by this. That is touching the limitation. Therefore, 33 is not applicable insofar as that point is concerned. Payment or non-payment of the consideration money. Then 34. We may look at the matter from one another angle. Apart from the aspect of fraud, the decision of this court in Kishan versus Rajesh Kumar, 2022-18 SCC 49. While looking into whether the defendant had paid any sale consideration to the plaintiff while purchasing the plaintiff's share in the property, held as follows. Therefore, findings in respect of or in regard to the payment or non-payment of the consideration money, not regarding endorsement, non-endorsement in the deed. Am I clear to Lordship? Therefore, these judgment as cited and relied upon by my learned friend is of no aid. On the to my lord establish the point that if there was no endorsement, the consequence or conclusion to be reached is that no sale money or consideration money was passed. My lord, here this judgment does not deal with that endorsement or no endorsement. Only regarding payment of consideration money or non-payment of consideration money. Am I clear to you? Then 33, 34. Here also a sale definition of sale from the Transfer of Property Act. Contract of sale. Then 35, as far as the facts of present matter are concerned, the plaintiff specially averred that she never obtained any sale consideration from the defendant. On this aspect, the plaintiff reads as follows. So, my lord, there is no discussions regarding the effect of non-endorsement of the payment or non-payment of consideration money, as per section 58(1)(c) of the Registration Act. Then Cal 2218 also has been relied upon here, as well as the other 72 SCC. All these judgments are relied upon in this judgment that I was just placing, Keval Krishnan versus Rajesh Kumar and others. So, my lord, section 54, scope of section 54. If no payment, no sale. Early, my lord, we need not deal with this when there is an admission of the offender.
So you are relying upon AIR 1977 Odisha 178, 1993 supplementary to SCC 611.
Yes.
And AIR 1999 SC 2213.
Yes. I'll play the paragraph particularly. Now, my lord, so this aspect we may now close here in my reply. Then, my lord, regarding that medical certificate.
The last issue.
Yes. Issue under substantial question 2. My lord, questions were placed to the witnesses, that is PW4 and also PW1. whether there was any doctor's prescription to prove that he was being treated by the doctor. They said no. Whether there was any medical document of ECG, CT scan, etc. They said no. Nothing. I have on the earlier question submitted that mere doctor's opinion or doctor's certification without being supported by the technical or scientific document, that is ECG or other scan report, etc., because it is a case of being unconscious, alleged unconscious, being attack, a cerebral attack. Somewhere they said heart attack, somewhere they said cerebral attack. Now in the certificate it is cerebral attack.
Cerebral thrombosis.
Cerebral thrombosis. Cerebral thrombosis and heart attack, quite different chapter in medical science. Quite different chapter. And I was evoked by the doctor while I was saying something like, identify both the cerebral and heart attack in respect of a father's treatment. However, it is not here, neither there. My lord, no document of diagnosis was placed in support of his opinion that he was suffering or there was a cerebral thrombosis attack of the patient. That is Hanchandra. What will be the effect? What will be the effect? I will rely upon two judgments. এটা কি আরেকটা আছে? এটা কি আরেকটা আছে? না, এটা পুরনো, অনেক পুরনো। It is a very old judgment. Arun Kumar Banerjee versus State, 1961. Equivalent citation AIR 1962, Calcutta 504. AIR 1962, Calcutta 504. Paragraph 46. I will just place 2 lines and then I will hand up before Lordship. Just 2 lines from paragraph 46. Although it is in a criminal case, 46 is a very 5-line paragraph. Mr. Dotto also argued that medical evidence was not conclusive in this case, but this criticism does not help the appellant in this case. We have already discussed the medical evidence. Medical evidence is hardly conclusive because it is primarily an evidence of opinion and not of fact. That was what Lord Roche said in the Privy Council case of Stephen Seneviatin versus the King, 41 Calcutta Weekly Notes 65 at page 77. To rely upon the findings of the medical men who conducted the post-mortem and the chemical analysis as decisive of the matter is to render the other evidence entirely fruitless. I'll kindly see paragraph 46, last page. Last page.
Lord Counsel,
My lord,
this was in respect of a
criminal case.
yes.
Criminal case. But the ratio laid down medical opinion not supported by any other diagnosis or other, what I should say, that report, diagnosis report, court should not accept it, because court is not the expert. Opinion to that opinion should be supported by some certificate. Here also no prescription of treatment, no clinical report, no clinical history, only certificate.
So what is your point?
Point is this, that these, even it is accepted, for the sake of argument, even if it is accepted, then also, I mean, accepted as evidence, then also its contents are not acceptable because it is a medical opinion without being supported by any clinical supporting clinical certificate should be there. Not that no question was placed before the witness. He said, I don't have. Both the PW1 and PW4. PW4 compounder, PW1 is the plaintiff, number one. Then, my lord, I also rely upon on this point on a judgment of Kerala High Court in the case of Law Society of India versus Fertilizer and Chemicals Travancore Limited, reported in AIR 1994, Kerala 308, Division Bench Judgment. Paragraph 186, 185 and 186. অসুবিধা লাগছে আবার। আচ্ছা, এটা একটা কপি দিও। হাইকোর্ট দেখবেন, হাইকোর্ট।
What is stated therein?
Later we may come to paragraph 186. Page
It has to be borne in mind.
Yes, it has to be borne in mind when assessing the opinion of expert that clearly it is not the province of the expert to act as judge or jury. All questions calling for the opinion of the experts are questions on which the ultimate decision has to be made by the judge. Expert opinion gets its weight and authority when the expert put before the court all the materials which induces him to come to the conclusion, so that the court, although not an expert, may form its own opinion on those materials. Very important. That was exactly I was trying to place before Lordship. It is opinion that he was suffering. No evidence, in spite of putting question to him. No, nothing available. Apart from, or keeping aside, whether at all S.K. Banerjee was a doctor in the area. I'm coming on this point later on. But on the
last three lines.
last three lines.
You are harping upon the last three lines.
Yes. Expert opinion gets its weight from. Thereafter, no?
Opinions
Must be supported by reasons, and it is the reason and not blank findings that is important. I'm grateful to you, Lordship.
Yes. Anything?
My lord. So, regarding my lord, this is regarding the admissibility or my lord, whether the
So
your lordship will.
substantial questions of law have been dealt with. certificate also dealt with.
Certificate of reality. Kindly consider one aspect. Although it is at the cost of repetition that compounder could not say before the court, in spite of suggestion made to him or question put to him, what is the name of your doctor? Esteban's full name. Could not say. Do you have any certificate of compoundership? Nothing. Could not. How far it is, his evidence is trustworthy. He himself, this is the very important witness to establish the case that Haranala was suffering from cerebral thrombosis. Cerebral thrombosis. He is the only man. But he failed to establish or to give answer or to say. He also could not produce or could not say that he has any certificate of compounder. Nothing. His evidence is very important. Very important. He is not trustworthy. His entire evidence should be washed away. Should be washed away. At all, not at all.
Yes.
Only one thing I just put to myself. When a doctor will give certificate, there must be, he said in the certificate, from since 28th August, he was being treated. No certificate, no prescription. No prescription. How is it? Not a single prescription could also be produced.
Anything more?
Well, the entire evidence of this PW for Romeo should not be taken into consideration. And on the basis of that, my lord, there was no medical certificate. And therefore, he was not at all suffering from any my lord, cerebral thrombosis. He himself admitted in the deed, I am ill. I am ill. That is why I am not putting my signature. I am putting my thumb LTI. He himself in the deed. Tola pate bola ache. Himself.
According to you, he had executed the deed.
Admitted on the basis of the registered. This much.
I believe that my learned senior friend has completed his submission. He will be not relying upon any other judgments.
আমি ওই শুধু যেটা আমি দিতে পারিনি সেটা আমি ওই I will only
They have relied upon, respondent has relied upon AIR 1977 Odisha 178, 1993 supplementary 2 SCC 611, AIR 1999 SC 2213, and lastly AIR 1994 Kerala 308.
yes. AIR 1962.
Yes, the AIR 1962 Calcutta 504.
Yes.
Altogether five citations.
Yes. I want to, my lord, place it on record by this court written notes of argument on the next date.
Let him place on the
What
But
the-
you have to deal with that.
Yes, please.
No, Milord. He is saying, Milord, that he
No.
will place another 2 judgments.
No,
No, not another.
He just said, Milord, he will be placing.
he could not provide the hard copy of those judgments. He has provided 1 and 2 hard copies. The other hard copies will be provided along with the written notes of argument. So, in reply, learned counsel, 2 p.m.
PM today, Milord.
Hmm?
So, Milord,
Why?
how many judgments have been relied, Milord? And next week, can you not fix it?
10:30 at on 30th,
30th.
10:30, along with written notes of argument, if any.
On that date, Milord.
Yes, on that date only. I mean, the learned counsel. Mr. Bhattacharya, reply at 2 p.m.
Next Friday. Coming Friday.
At 10:30.
Yes, 30th.
30th. ঠিক আছে রেডি করে
Mm, The learned counsel representing the
Defendant
respondents, respondents commences his further submission and concludes the same, and has relied upon the following citations. এক নম্বর হচ্ছে AIR 1977, উড়িষ্যা 178, 2 নম্বর হচ্ছে 1993, supplementary 2, SCC 611. Those hard copies which have not been provided, those be provided along with the written notes.
That is correct.
AIR 1999, SC 2213, and AIR 1962, Calcutta 504, and AIR 1994, Kerala 308. একবার মিলিয়ে নিন, বুঝেছেন? AIR 1977, Odisha 178, 1993, supplementary 2, SCC 611, AIR 1999, SC 2213, AIR 1962, Calcutta 504, and AIR 1994, Kerala 308. বলুন। Mr. Bhattacharya, learned counsel representing the appellants submits that he will give his reply on 30th of January. Let the matter be fixed at the top. 30th January for reply. Citation গুলো
61 AIR 1961 টা দিলাম তো? জি, ঠিক আছে। My lord, may I pray one indulgence? That AIR 1961 or 62 Supreme Court, I will replace after getting a Xerox copy. I'll keep it for myself for 10.
AIR
1961 Supreme Court, Calcutta. That criminal case.
Criminal case?
No. 62 Calcutta 504.
which one? That 302? 302 one, দেখি ওটা কত দিন? একদম ফার্স্ট লাইন,
এইটা
ফার্স্ট লাইন আছে 302 of IPC.
এইটা তলা এইটা দেখি। Yes. AIR 1962 Calcutta 504. I'll put it here after getting just code for that. I'll give it. No, দরকার নেই।
আবার ফেরত দিচ্ছেন কেন?
এই নিয়ে তো কি আছে, আবার প্যারাগ্রাফ মেলানো যায়, এই সমস্যা।
সেটা ঠিক।
হ্যাঁ, নিয়ে আমি দিয়ে দিচ্ছি আপনাকে, আমি পাঠিয়ে দেবো। উড়িষ্যা জাজমেন্ট প্যারাগ্রাফ 6 আর এখানে দিচ্ছে 11, 12, 13 আসছে অনলাইন।
যদি না থাকে তাহলে দেওয়া করবেন। তাহলে দেওয়া করবেন।
এনাকে দিই।
My lord is not coming back.
Yes.
Second half.
Second half.
শিক্ষার্থী ফ্লাইট আমরা যাচ্ছি না তো।
At least till 3.
3. বিকেলের flight.
At least because flight is second one. Evening.
Item number 2.
Lordship, I am for the appellant. That is that old second appeal matter, Lordship. Now we have. Yes, yes, yes. Yes. But now we have got the copies, Lordship, that we have got. But unfortunately, Lordship, two of the parties have died. So I have to take steps for filing substitution application, Lordship. One is within time, the other is out of time. So that I have to. Yes.
Within time.
Yes.
One within time, another out of time. Out of time is 2 go. Respondent
The
number 2
second
go.
appeal, in fact, my lord, one after another died. Substitution to substitution matter
Partition
could
through.
not be taken up.
Yes, yes, yes.
Since 1980,
No, no, no. Before that,
Right.
second appeal of 79.
second appeal
Very-
of 79.
Yes.
Very long. And the matter cannot be taken up for hearing since the
Let
substitution.
the applications be filed.
Yes.
Let us, not now, after
Yes.
the
Yes, yes.
substitution.
But
Standard.
Lordship, there is
Let
an
us proceed.
office
Apart-
report. Lordship will kindly see the office report, Lordship.
There's a lengthy office report.
Yes, I have gone through it, Lordship. But there was a direction that we have to put in some postal costs, but we have not. But Lordship, for them, Lordship, the learned advocates have already appeared.
Acha.
So that defect,
Need not be-
yes, yes.
That need not be necessary. And apart from that, lordship, that
Another thing is there is a Vakalatnama 4 series they have to
Step by
file.
step,
Yes,
let
yes.
us proceed. It is also submitted the non-finished of the records. Go. One co. Thereafter 1 to 6.
Yes. Even one core died, so 1 to 6.
This is like CPC.
It's
I have the experienced one matter, my lord, more than 100 years, second appeal in
No,
partition.
okay,
So
let,
this matter, not this matter. I got the brief, my lord.
Hmm.
The very old matter cannot be disposed of. Ultimately, the matter is settled.
no, let us,
This not this matter, but so far my.
let us make a sincere effort so that
yes, yes, yes. True.
Sleep না অনেক লোক লিখেছে
filing record of the amount duly has been served with notice of appeal. It is further submitted that in compliance with the admission, other postal notices were issued upon respondent number 1 go 1 to 6 1 go.
যদি মারা যায় তো ফ্রেশ বুকলানো ফাইল করতে হবে হ্যাঁ ফ্রেশ বুকলানো ফাইল করতে হবে যে কজনের অ্যাপিয়ার করছে সেটা ফাইল করো নাহলে তোমার তো অটোমেটিক বিকাম ইনফেকশাস
আপনি পুরো 1 সিরিজের হয়ে appear করছেন।
So, among these persons, 2 Gho 8 3 A B C D, that is 4A 4 Ko 3 A B C D, that is 4 Ko 4 Ko 3 4 Ko 4 4 Go 4 Jo 8. Anybody is being represented?
4 series, my learned friend is
4. You are representing all the 4 series. 4 Ko Kho Go
yes.
Jo, everybody. As regards to 3, so in respect of 2 Go and 3 A B C D, these persons are to be represented. You have filed Vakalatnama?
They have to file. Their Vakalatnama cannot be traced. Lordship will kindly see this report. These reports also indicate that on the second page.
Unserved with endorsement
Spot
left.
number 1 কত না
Postal articles have returned unserved with endorsement left
Yes.
in connection with respondent 2 GHO 8 with endorsement not found in connection with respondent number 3G with endorsement not known in connection with respondent numbers 3H 4. How can it be GH and Kokho Gogho? Is it so? 3G 3H thereafter 4 jaw with endorsement insufficient address.
1 কত জন আছে
In
1 এর
connection
সাথে 1
Respondent number, neither in postal article nor AD card has yet been received to this end. Correction with respondent numbers PF 44526. We humbly submitted that in terms of the administration, stated
এটা কি ফাইল করতে আসছে না
the defects regarding Wakalatnama filed by the Lawyer Advocate Debranjan Das.
Yes.
It is not traceable.
that is report
It is report, but order is there that only
ফাইলিংটা কোথায় সেন্ট্রাল ফাইলিং সেকশনে
Yes, the report is that despite that noting, but that Wakalatnama could not be traced
Yes.
out. So,
Just order to that effect.
yes, because there earlier lordship, there was an order of the learned Lojima administration that a Wakalatnama is there. But this report says that that Wakalatnama cannot be traced out. So lordship, to end all controversy, he may be directed to file afresh. But it may take some time because 4 series has many people.
very much concerned.
True, but it is not, if it is not traceable, what can be?
apart from that from the very beginning in the landed code below the respondent number 1 is contesting this case mainly they are not they are not appeared they are not appeared they have appeared in this high court
No.
no that is I'm not disputing about this
Once there is an order to that effect that a Wakalatnama has been filed, so they have entered appearance.
I'm not disputing about
What is the hindrance in filing a fresh Wakalatnama?
Perhaps something A plus, but
Will leave us that is not the concern of the court.
therefore I
one
think
one কতজন আছে কত
right before the register.
1 a থেকে
1 চক দিয়ে আছে আর
What do
কিছু
you
আবার
intend?
ভেতরে
Do you intend to dispose of the matter or do you intend to drag the matter?
No, I want to,
So?
I want to,
It will be better to provide a fresh Wakalatnama.
for two substituted persons.
Till now I am saying so.
তুমি যাদের যাদের হয়ে অ্যাপিয়ার করবে সব ভোগলাম ফ্রেশ ভোগলাম ফাইল করবে
For all.
আমাকে ফর অল কথা
না,
বলছে না তুমি যে
না,
কজনের
না।
অ্যাপিয়ার করবে তোমার নামটা যে এন্ট্রিটা হচ্ছে সেটা তুমি এন্ট্রি করো যে কজনের পাবে সেটা ফাইল করো তবে তো হবে
That won't be disputed by the appellants.
But 4 series lordship, there are a lot of people. When 4 died, he was substitute from Ko to Jho. And now several of these Ko to Jho have also died and they have been substituted
By
with Roman numbers.
1, 2, 3.
Yes.
তাহলে তো তোমার তো কস্ট বাড়বে তুমি তো অলরেডি তাহলে সাবমিট করতে হবে সবাইকে
তাই তো আপনি একটু খুঁজুন
otherwise matter cannot be disposed of
Order, rule, sub rule.
Yes.
matter cannot be disposed of
2018.
So many people. না দিলে কি করা যাবে দাদা
Has not received the requisites. So what to be done? Let it come from that end only. Name.
below this so far my response submission he apprehended as to whether all the all the substituted parties can appear or not he does not know the only thing is the notice should be served otherwise a lawsuit cannot be disposed of out of,
I've got the intention.
otherwise the matter can, he is apprehended as to whether all the parties appear or not to him.
And Lordship will kindly see the last part of the report.
না, না,
They are also,
ও তো apprehend করছে না, ও সবাই তার কাছে আসবে
it
না।
has been stated that I have not put special messengers in respect of postal cost in respect of some of the respondents.
আরে ওটা ছেড়ে দাও।
Lordship, they are appearing. Lordship will kindly note. Mr. Das is appearing for the 4 series and the rest, my learned friend. So no need to, Lordship, comply with that part, since they are already appearing.
Number 1 Gha, you are representing Gha.
Yes, yes.
1 to 4.
All, one,
And you are representing 4 Cha.
Yes.
1 to 7.
Cha. Yes.
4 Cha.
Yes.
Yes.
So that may be, Lordship, that part may be clarified, Lordship, that no need to put on the postal cost in respect of them.
Yeah. Then only the problem that is the wakalatnama is the problem.
Yes.
নিজেই ভয় পাচ্ছে ভগবানের পাবে কিভাবে।
সেটা যদি না তখন দেখা যাবে।
Let us counsel file the fresh wakalatnama and কি বলে
And considering the fact matter, very old matter can be disposed of.
সবাই
I don't think it is
from the very beginning, this is being expressed from this end.
Yes, yes.
So Mr. Maiti is representing
number 1 all,
1 Gha, 1 to 4.
all.
As such, service of notice upon 1 Gha Ek, English 1, GHA Gha, bracketed, Roman 1 to 4, bracketed. 1 to 4 need not be served with notice, except appellants are exempted from serving notice upon 1 Gha, 1 to 4. Okay? As regards to 4 Cha, upon 1 Gha, bracketed 1 to 4. Full stop. 4 Cha, 1 to 7 is also being represented by Mr. Romane. 1 2 3 4 যখন দেবেন ইংলিশ 1 2 3 4 প্রথমটা আর ব্র্যাকেটে খ হলো জিএইচএ আর সিএইচএইচএ 6 আর রোমানে হচ্ছে 1 to 4 আর 1 to 7 মানে is being represented by Mr. Dash. As such, the appellants are exempted from serving notice upon 4 Cha 1 to 7. And 1 Gha 1 to 4 আর 4 Cha 1 to 7 হয়ে গেল, কমপ্লিট হয়ে গেল। এটা হলো এবার মিস্টার দেবরঞ্জন দাস who is said to have filed the wakalatnama on behalf of the respondents number 4 series has expressed to file a fresh wakalatnama on behalf of the said respondents. As such, the learned counsel is requested to file fresh wakalatnama on the next date. And anything more?
And Lordship, regarding the service, regarding respondent number 2 and 3.
2 and 3, 2 Gha 7, 3 A, B, C, D.
Lordship, there one has come back with endorsement left. Some not known.
Not found and not known.
Lordship. Now these are not good service. So whatever, I leave it upon your Lordship. Because they did not contest in the court below, but at the same time, this is a partition suit. So this portion I leave it upon your Lordship.
They are relatives of yours.
Maybe, but they are perhaps not willing to come. What can be done? Because all the parties are somehow related. But if
In
they are,
a partition suit, nobody is a loser. Everybody is a gainer.
but maybe
Even that, it is a partition suit, my lord. It is the relating to the share.
Mm.
It is relating to the shares. My lord, some person did not interested to appear. What will happen? The share will not be goes. Share will be stand.
So, fresh attempt or
It should
Paper publication will be too much.
too much. Then the other alternative is one more attempt.
তাদের উপর সার্ভিসের জন্য একবার টাকা জমা দেবেন রেসপন্ডেন্ট নাম্বার
আর জানো না
না না মারা যায়নি 2 বা 3 এই যে এরা এসব গোপাল মহারানী তো মারা গেছে এই যে গীতা রানী গঙ্গা হ্যাঁ হ্যাঁ না ওদের ভাই বোনরা আরেকবার নোটিশ দেবেন কারণ ওদের উপর নোটিশটা কমপ্লিট হয় না
my lord, the question, my lord, so far my little knowledge, if it is a partition suit, attempts has been taken, person did not appear. My lord, from the records, kindly appreciate, this is the about third times date is fixed for hearing. Final, all the could not be taken up for hearing due to. That's true.
On the other hand, procedures should maintain, otherwise
That is
will be after all.
that is no. Why I am submitting before lords? Why I am submitting before lords? That person did not appear in the learned court below. They did not contest at all.
yes lordship
If in spite of the second attempt,
because in the meantime lordship we will be filing that substitution application within that time lordship let that be carried out
they can do three.
yes
Three and
only
three.
no expired now has 2 go and 4 co
Oh, DHA.
2 go is Shobharani coil
In respect of eight. What about port 4? You are implemented upon. Port job. 7-9. 7-5.
যতীন্দ্র মন্ডল এদেরকে তো এরাও তো কেউ অ্যাপিয়ার করছে না
একটু আগে সময় করা হয়ে গেছে তারপর কি করে
সেটা করলে কি হবে এখন রেজিস্ট্রেশনের প্রসেস আবার করতে হবে লর্ডশিপ উই উইল এগেইন স্যার through the department lordship yes
ডিপার্টমেন্ট পোস্টাল কস্ট জমা দিতে হবে
yes 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 সোমবারে হবে মঙ্গলবার within Tuesday lordship yes yes appellant sole appellant yes
appellant that
respondent number 2 go
namely
Shobharani Koyal. And 4 Ko, that Ajit Kumar Mondol. Lordship kindly keeps the matter on 30th, Lordship. Yes, yes. Because our application is ready.
Only one line order, my lord, should be recorded. Since the very old matter, all the my lord, steps were taken immediately and the matter taken for it. Yes.
Lordship. Lordship.
Sub all.
One series.
All series.
Item number 3. I'm appealing for the appellant. This is there are two applications. One is application for stay, second appeal admitted. Admitted, question was framed also. And in the meantime, the appellant number 1 died. And appellant number 2 is a son. Admittedly, he is on record. Only recording of that date of appellant number 1. That will be the dispose of the application.
The name should be expunged.
Deletion হলে যাই হোক
শুধু রেকর্ড করে দিন ডিপার্টমেন্টই করবে
ডিপার্টমেন্ট will do.
ডিপার্টমেন্ট উইল ডু ডেফিনেটলি আমরা কি
She has died on 16 September 2023. I have made an application. Can number 2. 2 of 2024. Para 7, page 3. One. She has died on 16 September 2023. Death certificate is also annexed. September 2023. Appellant 2 is a son. Already on record.
recording of death and
But another thing is that admittedly second appeal admitted. There is a application for stay at the relevant
that
time.
will I shall-
ঠিক আছে। We cannot file.
yes, yes. Appellant now will
Number
be one
one.
appellant.
And has expired on 16/9/2000.
His son, Indranil Chatterjee.
Such the
Appellant number 1.
Appellant.
as such, no further step is required. Already on record, as such, no further step is required. Only the name of the appellant number 1 is to be deleted. Department to do the needful. Full stop. It's a department to bold kore debe. Yes.
There is another.
Cat 2 is disposed of. The learned counsel representing the respondent or respondents.
Respondent 1.
One opposite party.
Omeo.
Omeo.
Does not raise any objection. Full stop. Yes. Next.
Another application is applications for stay. Admittedly, second appeal admitted.
Suit for
Declaration and permanent injunction. In respect of a permissive possession, and he is claiming adverse possession of a land. Both trial court dismiss his suit. He was the plaintiff, but appeal court reversed it. On that basis, we prefer an appeal. Appeal was admitted. You kindly see the grounds of appeal also annexed to the appellant also. But at the relevant time, we cannot do it as because the mother, the appellant 1 was seriously ill. He was in hospital, subsequently died. That's why you cannot do it. After that, I have filed this application, which is annexed to the petition of the stay application, page 12. This is.
Is it required or the entire appeal can be
disposed of?
But only thing is, in the meantime, if they alienated the property and the transfer of the property.
As of date, there is no alienation. He also knows that because he is residing in that.
Whatever it is.
So,
in whose possession it is?
I am in possession of my part.
Both of us. Both of us.
Sorry, sir. We have some part of the land we are in possession, some part of our land they are in possession. They are claiming title on the basis of that land. So, trial court dismisses suit, appeal court reverses in the first step.
That can be settled now, even now. Settle means in the sense if both the parties agree to non-alienating.
That is true.
To that, I shall controvert this application. I shall defend myself. Kindly fix it any day. Today, it appears as to be mentioned. I also looked it very late. And we all were under the apprehension. Yesterday was the Friday, so-called Friday.
Only innocuous order not to transfer this land. Or
kindly keeps it next Friday. I shall do it. Next Friday, next Friday next week.
Can
number 1.
Can 2. Can 2.
Can 1.
1 of 23.
23. That is can 1 of 23.
Admitted on?
Yes.
Admitted
on, my lord. This is admitted on
June 2023.
30th June 2023. That is annex.
30th June 2023.
Yes. Page 12.
At that point of time, you are not filed.
Yes. Automatically, it can be stay was granted once it is admitted.
No.
No.
How can we? Automatically.
No, but not mechanically. If some cases is there.
Filed it on 19th of July.
Yes, my lord. Now, I explain it with the all medical certificate is also there. Subsequently, she has died also.
There was 2 appellants.
No, this may be the
what will be the further order from this end? If you file an affidavit in opposition.
No, I will orally argue. I will not go for opposition. I'm not asking for opposition. But I will orally argue. I will orally defend myself. Because this is matter of record.
30th.
Let his statement be recorded that
kindly takes me assured. I am not that civil court lawyer who will unnecessarily go for an affidavit in opposition.
That's why it can be disposed of today itself.
No, but I need to look up the records. Okay. If I need to orally defend, but I need to look up the records.
Orally defend or orally assure the court? That's which step do you intend to take?
Orally will defend my client and orally assures the court. Even that, I will not use an opposition.
That cannot be done now.
No, the defense part, kindly give me.
Can 1 of 2023. The learned counsel representing the respondent. The respondent seeks an accommodation to seeks an accommodation and submits that he will verbally press his submission on the next date. As such, let the matter appear on 30th of January under the heading application. Application আমাদের আসছে তো?
Right, as a to be mentioned so that it can be called.
Again, but to be mentioned under the heading
And also
application.
recorded is assurance.
No,
They have
that
not
is
transferred
always
it.
there.
Only they have not transferred it, that is way.
Millard kindly looks to his application. Has he ever anything made factual assertion that I'm doing that, doing this? Kindly looks into this.
Yes, sir. I say so.
If he has not averred, then why should I, Millard, argue on Millard filing an opposition affidavit in opposition? Millard, this much courtesy I have, I will not unnecessarily delay. He has said there was a suit, there was an appeal, there is a second appeal, admission.
More was expected from your side. Bit more. Yes, Lord Counsel, which paragraph?
Yes, Millard, I am saying.
There is nothing to assert that.
You know,
That's why
para
it's a Millard.
21, para 21,
21 of what?
page 8, last slide. Kindly see.
Yeah.
Applicant petition state and submit that because of the passing of judgment degree, that it lower first court responding herein may at any time transfer the said property, suit property in various way by taking advantage of said order. We have stated.
Let me come back, Millard. I shall
Yes,
ask.
prejudice to the appellant hearing.
So, Millard, there is no question of using opposition.
That is true, but
No.
at least his assurance be recorded.
না
That's
আমি
right.
একটু দেখে আসতে চাইছি আর কিছুই না
Application heading as.
Millard, as to be mentioned.
No, under the heading application. Why to be mentioned?
as well as
They may not take enough. That's why I
Huh?
may not take enough.
No, no. Under the heading why under the heading to be
No,
mentioned?
we'll take 1 minute. That's why I'm saying let
That
it be
nobody
appear as a
knows.
to be mentioned.
that nobody knows 1 minute.
To be mentioned is in respect of other matters.
Exactly.
No,
Much of
then if that's so, let it be recorded his assurance. before
I'm
the court
saying
also.
there is no factual
Yes,
assertion.
yes,
Why
yes.
should I?
Yes.
So the is in open
No,
court is
officer of the court.
stating
This much. Millard, he knows me for a pretty long time. I will not use unnecessary opposition.
তোকে আমি অনেক বছর চিনি।
being a legal officer.
Okay, all right. Fine.
Then next.
Item number 4 and 5.
And I led by Mr. Simongol Singh, my lord, only section 5 has been served.
That is required. That is you are entitled to.
How many days delay?
5 days only, my lord.
Yes. You are the advocate on record.
No,
What to be?
I led by Mr. Simongol Singh, my lord. I prefer not to them.
My lord, I am suffering execution case is pending, my lord.
Direct counsel.
But 5 days.
What to be done from this end? There is a you
Yes,
know.
yes.
So?
But when my learned friend appeared before your lordship and asked for accommodation, well, it is 5 days delay. I am suffering for 2 months with this application. Now
After all, if any order is passed, that is against. Huh? No, it was
whenever it will be taken up, there will be a prayer from the other side for accommodation. I know it.
1 minute. Today, there is another proviso. From that end, there is a resolution.
Leaving a part of the, happening of this day, but in future days, whenever it will appear, they will never be ready with the application.
Learned counsel, you have received the copy of the section 5 application. Be ready on 30th. Request your senior or otherwise you come ready. Next.
Item number 6.
My lord, I'm appealing for the state respondent.
WPA. Order required. এই আগেরটা order note হয়েছে না আগেরটা? হ্যাঁ? No. Order. যেটা লাস্ট যেটা সেকশন 5 এর অ্যাপ্লিকেশনটা এটা কোনটা 4 and 5 ছিল ওটা 4 with 5 section 5 4 and 5 I don't know 4 and 5
More than five, for the appellant.
order not করেছেন
Appellant petition.
না না ওই লর্ড কাউন্সিল ওনার নাম নিয়েছেন আগেরটাতে নাম নিয়েছেন
আগেরটা 4-5
আমি না
চলে গেল।
দেয়নি চলে গেছে
না অর্ডার পাস করতে হবে নাহলে হবে না learned advocate representing the respondents seeks an accommodation for this day. Let the matter appear. Let the matter appear on 30th of January. ওনার নামটা দিয়ে দেন ঠিক আছে yes
মানে day has been
Hi.
fixed.
30th item number 6
6, I'm for the petition.
I'm
Actually,
appealing
my
for
lord,
the state
last
response.
occasion, my lord was pleased to direct me, my lord, to serve notice, my lord. Somehow, my lord, I have missed it, my lord.
extension
Kindly, my lord, allow me 2 weeks time, my lord.
2 weeks
2 weeks, my lord.
the learned counsel representing
বলুন আপনি যদি অসুবিধা হয় বলুন
না না ঠিক আছে
আপনি বলুন না
the learned counsel representing the
petitioner
seeks an extension of time to serve notice upon the private respondent
Yes, ma'am.
upon the private respondent as well as the pradhan
upon the private respondent who is the respondent number
5, 6 and 7 my lord.
তাহলে private respondent
Private respondents 5, 6, 7.
private respondent number only one
No,
private
no.
respondent
private respondent number 7
respondent number 7
that is respondent number 7
and 6 and 7 my lord.
and upon the respondents number 6 and 7 that is Pradhan Kamrabad
Gram
Gram
Panchayat.
Panchayat and Block Development Officer Sonarpur Development Block and you are representing whom 1 2 3
My lord,
or 1 or
state
2
is
1 or 2 1 and 2
1 and 2 my lord.
1 and 2 so the respondents number 1 and 2 are being represented full stop. As extension to serve notice as extension has been sought for
3. My lord, 1, 2,
Video.
3, 4 my lord.
8 also video খালি
Video.
5 6 and except 5 6 and 7 I
Yes,
think
yes,
so
yes, yes.
only except 5 6 and 7 my lord he appeared
let her submit
I think so
being confirmed
My lord, I
who
have
you are
1
representing
to 4 my lord.
do you have the brief
My lord, I have
1 to 4 and 8 also
my
you are
lord,
representing the
state respondent my lord 1, 2, 3 and 4 my lord.
1 2 3 and 4
Yes my lord.
police authorities are also being represented by you
Yes my lord.
তাহলে respondent number 1 2 3 and 4
My
are
lord, and also 8 my lord. 8 my lord.
go through
No my lord, 8 video my lord.
তাহলে তো 8 এর কথা আগে বলা হতো না।
50
নাকি 5 6 7 এর কথা বলেছি 5 6 7 ঠিক আছে তাহলে তাহলে হ্যাঁ ভিডিও তো বললাম তাহলে ভিডিওটা কাটুন
actually my lord
2, 3.
last occasion my lord was pleased to
one
my lord,
so you have to serve notice upon 5 6
6 and 7 yes
5 6 and 7 ঠিক আছে ভিডিওটা বাদ দিয়ে দিন ভিডিও নয় কামরাবাদ গ্রাম পঞ্চায়েত প্রধান of কামরাবাদ গ্রাম পঞ্চায়েত
and the private respondent
and the private respondent ঠিক আছে respondent number 7 হলো clear and the respondents number 1 2 3 4
3, 4
and 8
and 8.
are being represented let the matter appear on 6th of February 6th of February
get room
Item number 7.
Item number 7, I am for HON'BLE Corporation, led by Mr. Sandeepan Banerjee.
Are you enlisted? No.
Yes,
Are you enlisted in the panel?
no.
Not
Mr.
today.
Sandeepan Banerjee
Not
enlisted.
today.
I am
Not today.
grateful, Lordship.
Item number 8.
Not today.
Item number 9.
My lord, I appeal for the corporation. My lordship, kindly your last order. See your last order. Lordship, kindly see.
Not to be opened today. Because there is an from that end. Not today.
Not today.
Order required.
Yes, some order is to be required, my lord.
That you submit. Then
So that I can communicate. I appeal on behalf of the corporation too.
only that word is required, whether order required or not.
Order is required.
That is more than enough.
Grateful, Lord.
No. It's
Sir.
item number 9. Item number
On behalf of the KMC.
the Kolkata Municipal Corporation is being represented. Let the matter appear.
My lord, no one appeared on behalf of the petitioner.
No adverse order.
I'm grateful.
You have obtained what is required. As there is a resolution of the bar, as there is a resolution of the bar. So, in the absence of all the sides, the matter is not being. In the absence of the petitioner, the matter is not being taken up. Let the matter appear on 6th of February.
6th.
Item number 10.
Lord, I have heard today only one thing, my lord, that we have already sent the copy to the restoration petition. Restoration of the revisional application dismissed for default. I have served the copy. An affidavit of service is there. Let it be kept with the record and let it be fixed on 30.
Lord Senior Counsel, not today.
Lord, so that I can give notice to them, my appearance will be there. No adverse order I am claiming, only order I am claiming. As your lordship, what is falling from your lordship? Lord, only the affidavit of service be kept with the record. This is the affidavit of service.
Mr. Banerjee.
Item number 12.
Thirteenth Lordship, I am for the plaintiff opposite parties.
Plenty opposite party.
Lordship, if initially one of the opposite party expired, the court directed the petitioner, Lordship, to file an substitution application. Subsequently, matter has been dismissed for default. Now restoration application has been filed against a dead persons, and subsequently after 1 year, the substitution application filed with the lordship the condolation of delay and abatement. Set aside in the
What is the impugned order?
Order 26 Rule 9 that was rejected. Revision.
Some dispute regarding a plot.
Plot.
3 feet or 1 feet or 2 feet. How much feet?
Also, they are raising that they are in the possession. We are not in the possession. They are claiming that
investigation.
Yes, investigation. As there is no allegation of encroachment, so application has been turned down. Lordship, Order 26 Rule 9 has been turned down. Now, Lordship, they prefer a divisional application. It was pending for a long time. In the meantime, one of the Lordship, the opposite party expired.
Sole.
No, there are 3 opposite parties. One opposite party expired.
One is to be substituted.
One is to be substituted. Lordship, when the liberty has been given, Lordship, they did not appear, matter has been dismissed for default. Now the situation is, Lordship, whatever will be the first application. If it is a restoration, then restoration against the dead person cannot be maintainable. If it is a substitution, substitution cannot be acceptable because matter is no more.
If the tree is not alive, how can the substitution take place?
No, so the 3 opposite parties.
Tree.
Yes, that is the
tree is to be
yes.
First.
That is. Now, if it is a restoration application, your lordship's taken up, then restoration application against a dead person, how it can be, lordship? I'm asking myself. Now, last occasion, my learned friend who is appearing for the petitioner could not, lordship, substantiate, took time, and this is the before your lordship.
First, the restoration will have to be taken up. It will have to be restored.
Then I am asking myself, lordship, restoration against the dead person.
Unless and until the matter is restored, how can the substitution be taking place?
Lordship, that is, lordship is correct. But lordship, my objection is then how this restoration application is maintainable against a dead person. Because one of the person already dead.
2 of them are there.
There, but one is dead.
But if the matter is not restored, how can the substitution petition come up?
This is also I'm asking also.
If the stem is not there,
yes.
How can the branches come up?
Yes. But lordship, this is my objection to this restoration application. The restoration application, a dead person, how it is maintained.
Mr. Banerjee, Mrs. Chakraborty. Mr. Banerjee.
Lordship. Lord, used to file an application for substitution in the restoration application.
The question which has been raised that whether the restoration application is to be taken up first or the substitution application is to be taken up first.
Lord, substitution cannot be taken up unless because in this
unless and until the matter is restored, how can the substitution be taken up according to?
Lord, my view is, my Lord, restoration application means practically there is no longer no appeal is not there.
The tree is not there.
Yes. Now, tree is not there.
Until
now,
the stem,
how branches will be there? Now, Lord,
Restoration application.
in the event the prayer is made.
That, lordship, to that extent, I am, lordship,
in the event that application is made. Lord, in the ordinarily, my Lord, in the restoration application, practically, when substitution application was filed, certainly in the restoration, at that time, restoration application was not there because that was not dismissed for default. Was there. Then in the restoration application, my Lord, then ordinarily, in all cases, this prayer is made.
No, I think in this case, one has expired much prior to the matter being dismissed.
Yes.
I think so.
Yes.
Yes, much prior to matter is dismissed.
Substitution petition was pending.
No. Lordship, revisional application was pending, expired, then dismissed for default.
In the meantime, there was no substitution petition.
No. After then restoration application, then substitution.
Therefore, that substitution application, including the restoration petition,
That can be
including the restoration
that
petition.
can be made through a
Yes,
single
that
application.
without technical torture.
How many applications they have filed?
Let's say, as on today, let's say 3 applications are filed.
না, ওখানে prayer দিয়েছি কিনা দেখুন।
No, simple restoration against the dead person. Simplicity restoration. Kindly come can 1.
Substitution এ কি বলেছে?
Substitution of the substitution file in 23.
তাতে কি
That is legal heirs of the defendant number 1.
আর আরেকজন মারা গেছে 2টা।
1 যে মারা গেছে।
হ্যাঁ 1 তার
Can
restoration
1 of 23
is a restoration.
is the application for restoration prayer.
Yes.
Prayer in the circumstances of the present petition.
Unless you kindly see what is cause title relevant. Cause title is dead person.
Please to pass the order direction or directions to allow this application for restoration after recalling order and keep this in hand. This is herein.
So Amit Dan has expired. Now restoration application is against Amit Dan.
Can 2.
Can 2 is the lordship the
Section 5.
Can 2 is the no. The can 2 is the substitution.
Substitution of
No. Can 2 Section 5 of Limitation Act 1963. I think the substitution prayer has been made later.
So here is the can 2 is his application for substitution.
Can 3 is the application for substitution. Can 3 of 23. An application for substitution of the legal heirs of defendant number 1, opposite party number 1.
Lordship, here is, I don't know, Lordship, the served copy has been served with the endorsement 2. Can 2. Whatever, Lordship, can 3.
substitution section 5 করেছে আবার।
Substitution section 5, yes.
তার মানে setting
Yes,
aside
section 5.
abatement 60 days, 90 days,
90
60
days
days,
plus 60 days.
plus then section 5.
Then section 5.
Yes,
But also in a revisional application, the time period is 3 years.
3 years. Lord,
No,
তো আপনার বাবা ফাইট করেছিল আমি তার জজ হওয়ার আগে। Lord,
Now,
I
Lord,
was the
kindly, what
counsel-
is the
Lord,
problem?
I was the counsel in that Justice S.N. Mollik, that whether 90 days will be the date in the case of substitution of a revisional application. Her father, my Lord, argued the case before elevation. Argued that no, this will be 3 years.
Yes, sir.
But in that case, court held 3 years
3 years.
limitation.
Ultimately, now it is 3 years.
3 years.
So the section 5 is redundant.
Redundant, Lordship.
So
Now,
we will have to
dispute,
cons-
so section 5, I am not opposing. What this is
No.
the troubling me.
No,
He used to file an
We can-
application then for
Now, this is the
Sir.
troubling me, Lordship, what happened? Kindly see the restoration application and substitution
no, if
side by side.
now one minute. Lord Counsel, now 3 years have passed by. Now,
No, 3 years has not been passed.
no, in this
No,
matter, 3 years.
What is troubling?
yes.
Whether 3 years have passed by or not.
No,
the
3
date
years
of
not been passed.
When the person expired, that
Yes. The
Ma-
person expired on
Sorry.
19th August 2020.
20.
20. No, Lordship, the substitution application within 3 years.
Then everything
No,
goes.
because,
Then substitution
I think
application.
1 and 3 has to be taken up together.
Yes. That is
Lordship,
to be
first
taken
of all,
up.
Lordships wants to restore the revisional application first. This is the Lordship's view. Lordship, kindly come to the restoration application against whom?
In that, we won't get into the merit of the matter now.
No.
Because in the absence of the other side.
Yes, obviously, Lordship. Today I am not praying for any order.
This one is for academic discussion.
Yes, obviously.
Till
Lordship, I am on-
this moment.
That is the problem. Lordship, the restoration application
But-
against a dead person.
What I was thinking is that if it would have been within 3 years, then they could have been allowed to file a fresh application seeking both restoration and substitution
Right.
through one application. But that 3 years have also passed by. Now
That
these two applications have to be
question
relied upon.
Now, Lordship, this is because the Honorable Coordinate Bench on the same issue point, Lordship, the asked both the persons together that when a revisional application has been dismissed and dismissed after the death of the one of the parties, then restoration against the dead person cannot be allowed.
No, that is why, my lord,
That
prayer
is the law.
prayer is to be corrected.
That is
Prayer
the law.
to be corrected.
Now, Lordship, if
What's
we
my
want to substitute this application, then substitution cannot be entertainable because this is no longer, Lordship, live.
But it is also fact that that person, the legal heirs of that deceased person,
yes,
is a necessary party.
It's a necessary party.
He is to be
Now, Lordship, this is only can be, Lordship, my learned friend, what is saying that in the substitution in the restoration application, a substitution application has to be filled connection with the restoration application.
In the substitution application, prayer, lordship, that has to be incorporated along with in the pending application.
Separate substitution application.
It has because that time period has passed.
When dismissed?
Lordship, dismissed in
No, that not when the
dismissed with the restoration application within time.
So I think
an application for amendment is there, my lord. Doctrine of
So dismissed on 26
doctrine of relation
September 2023.
doctrine of relation
26 September 2023. The restoration within time, within 30 days.
One thing can be done, they can be allowed to file a supplementary in respect of the restoration application.
Restoration application, there should be a substitution application. That can be to some extent, I think.
Saying substitution also in the restoration.
Restoration application. That to some extent, Lordship, maybe.
Yes. The expression was not correct. They are to be given an opportunity to file a supplementary affidavit in the substitution application to incorporate restoration.
Yes.
Substitution.
That will substitution in the restoration in the substitution application.
No. That's a substitution application in the restoration application.
Not because restoration application against a dead person.
Yes.
His point is that it cannot be restored against a dead person.
In respect of a dead
He's
person.
right, so far that part is concerned. He is right. But that can be remedied by including
substitution in the restoration
by
application.
making a supplementary affidavit including that prayer.
Substitution is there in
Is there?
respect of the main application, main revision
Yes,
application. In that prayer, they have to
No.
just
Not in the revisional
Restoration
application.
application file করতে হবে।
in the main application, main revisional application, along with the pending application, which is the restoration application.
To some extent, Lordship, I have.
Application is there.
Yes, Lordship, the prayer in the substitution application is substitution.
Only substitution
Main revisional application.
in the main revisional application.
In the revisional application, along with in the restoration application. Like which we do in the appeals. We pray for substitution in the main memorandum of application.
Yes.
Pending application.
In pending applications. Yes.
Just like that.
Just like that.
Yes.
To some extent, Lordship, I have convinced that can be done.
That is supplementary affidavit is to be
Yes, supplementary
affidavit is to be filed for incorporating substitution in the restoration application. And then restoration, then
this
then my lord, substitution.
Civil revision also.
Then civil division also.
So
Lordship, the next Friday.
the main contender are not there.
Yes. Oh, that's it.
Not today. Next.